So what are some of the reasons or factors for us to set aside or to resist enforcement of this award? Now, the first of which is if they find that there's an incapacity of a party, say that party doesn't have authorization or the right to be in this arbitration. The second is if they found that the arbitration agreement itself is invalid. For example, certain arbitration clauses, if not properly drafted, will be rendered to be invalid. So some examples where arbitration clauses have been rendered invalid is, say, in the seat of arbitration, they stipulate two jurisdictions. They say, for example, that seat of arbitration is Singapore and Jakarta. Now, this would render that arbitration agreement invalid. The other aspect, and there's a lot other points here, but I'll focus on the few main factors or reasons that are usually raised when you try to set aside or to resist enforcement of an award. And one of which is where a dispute or an award falls outside of the scope of the arbitration, where it's in excess, ultra vires as we call it in common law, in excess of jurisdiction. So what happens? So what's an example of this? So for example, if in an arbitration, we are talking about a breach of a contract, and all of a sudden, in the arbitration award, the arbitrator decides on another issue apart from breach of contract, which parties never raise. In courts, that's permissible. Courts are allowed to sua sponte, decide on certain things that parties might not have raised. But in arbitration, if that happens, then the arbitrator has exceeded his authority, his permit. Because remember, like what I said earlier, arbitration is a creature of contract. The authority of an arbitrator and the scope of the arbitration is held within the limits and the bounds of the arbitration agreement itself. The arbitrator cannot go on and decide on any issue. They can only decide on an issue that parties have raised. Now, another point that often is related to this issue of excess of jurisdiction is breach of natural justice. Very common reason, and in fact I would say that it's 90% of the time when you try to set aside an award or try to resist enforcement, the argument would be a breach of natural justice. Now, what is a breach of natural justice? Now, from Singapore law context, breach of natural justice contains two components. One, we're using a fancy Latin term, nemo iudex in causa sua, meaning that, if the arbitrator is biased or partial, shows signs of biasness, then you can set aside the award. The other component of breach of natural justice is in audi alterum partem, which means that the right to be heard has been breached. So what's an example of a right to be heard has been breached? Say, for example, one party raises a particular argument, and the other party did not have a chance to respond to this particular argument. And then in the final award, the arbitrator decides on the award in this particular party's favor, based on the argument that this party has given. And this is a breach of right to be heard because the other party did not get an opportunity to present their case or their defense as to this argument. So essentially, the arbitrator has only heard one side, and based on that argument, they've used it, and used it in his conclusion or reasoning for finding in a certain way in the final award. Now, this constitutes a clear breach of natural justice. And so there is at the bottom there, again, I found a very interesting case in Singapore related to Indonesian parties. Again, Indonesian parties have been making a lot of landmark arbitration law in Singapore. And so this is PT First Media, which is some of you may know to be one of the companies owned by the massive Lipo Group in Indonesia. And this is Astro Nusantara, and Astro is again a large Malaysian conglomeration. And this dispute in particular involves a failed joint venture between the Lipo Group and the Astro Group. And what happened in this case was that PT First Media had found their argument was that the arbitrator was in excess of jurisdiction. They did not have jurisdiction over this particular arbitration. And so they argued, in the arbitration, they argued before the tribunal and said that, look, we don't think that you have jurisdiction over us. So the tribunal gets to decide, whether it has jurisdiction or not. And in that case, the tribunal decided that it has jurisdiction. So this particular arbitration is seated in Singapore, and so under Singapore law, we have incorporated the UN model law in this regard. And Article 16.3 of the UN model law gives parties, when they challenge the jurisdiction of an arbitral tribunal, and a tribunal finds that it has jurisdiction, parties have 30 days to appeal this to the national courts, to Singapore courts to decide this. PT First Media took the approach of not using this recourse. So basically what they did, they challenged the jurisdiction of the tribunal, and they failed, but they had actually this recourse under Article 16.3 of the model law to go one step further, to go up to the Singapore courts, and they chose not to. And so this arbitration ran its full course, and again, the outcome was not favorable to PT First Media. And what happened then was that when Astro Nusantara sought to try to enforce the award and all that, PT First Media went to the Singapore courts, because Singapore courts is the seat of arbitration, and they sought to set aside the award on the basis that the tribunal did not have jurisdiction. So this is a very interesting case in Singapore, because what has parties argue vigorously about it. Astro Nusantara said that, look, PT First Media, what they should have done is that if they really think that the tribunal had no jurisdiction, then they should have argued all the way, after the arbitrator decided it had jurisdiction, you should have used Article 16.3 of the model law and go to the Singapore National Courts to determine whether there is jurisdiction or not. You can't wait until the award is out and it's not in your favor, and then you try and set it aside, try and keep this card to your chest, this particular ace up your sleeve, of jurisdiction. So what should be the correct answer in this case? It's a very difficult point of law, and both parties hired eminent barristers to help argue this case. And ultimately, the Singapore court decided that PT First Media could set aside the award or resist enforcement of the award on the basis that the Article 16.3 of the model law is not a recourse where if you don't use it, it's gone entirely. They took the approach that there is a difference between an active remedy and a passive remedy. So an active remedy would be if PT First Media had argued the jurisdiction issue all the way up to Singapore courts. They say that is one way to do so. But there is also a passive remedy where they wait for that award to be enforced against them, and then they bring out that trump card of there's a excess of jurisdiction against the tribunal. They say that this is doable, and so it's quite a controversial judgment in this regard. But again, something very interesting, a strategy when we go to an arbitration, in case that some parties are thinking about how do I protect my rights and all that. So what this case shows is that you can try to challenge the arbitrator's jurisdiction, and if you fail it, as long as you reserve your right to do so, and you continue with the arbitration, and when the award is issued, what happens is that you still have this recourse to resist enforcement or to set aside of this award on the basis of excess of jurisdiction. So this is a particular strategy, and that parties need to be a bit aware of. Next slide, please. So, in terms of challenging the award, I have produced here, an extract of a Hong Kong court judgment. I was involved in resisting the enforcement of an arbitral award against our clients in the Hong Kong courts. Now, it should be noted that the Hong Kong courts are notoriously pro-arbitration, so it makes it very, very difficult to try and set aside or to resist enforcement of an arbitral award. They have an extremely high threshold, to try and resist or set aside an arbitral award. And I believe, somewhere it says that, in the entire history, of Hong Kong, there's only been like 30 cases where an award has been set aside or resisted, enforcement successfully resisted. And I'm very proud to say that one of my matters, this constitutes one of the 30 in Hong Kong's history. So this is a pretty interesting case. Maybe a bit of facts about what happened in this case. And basically, the facts are not so important, but more of like what the strategy or what the particular issues were which allowed us to succeed in resisting the enforcement of this award. Now, what happened was that there were closing submissions after the arbitration. So what happens is that, after the arbitration hearing is done and dusted, parties are given the right to submit closing submissions. And in this particular arbitration, the closing submissions were simultaneous. So both parties had to file their submissions on the same date and on the same time. Now, we filed our closing submissions simultaneously with the other side. And what happened was that the other side used these closing submissions to include new arguments into their closing submissions. And so we didn't have the chance to reply to it because they were submitted simultaneously. And fortunately for us, the arbitrator in this case relied on the other side's new arguments as a basis for a finding against our client. And so we latched onto this point and we went to the Hong Kong courts to resist enforcement on the basis that there was a breach of the right to be heard under the Hong Kong Arbitration Ordinance. Now, this award, this judgment where we successfully resisted enforcement of the award is public. So, if you take this down, X against Y 2020 Hong Kong Court of First Instance 2782, you search on Google, you get the full judgment of it. But I've just produced the relevant extract showing what's the decision of the Hong Kong Court judge in this case, the rather infamous Mimi Chan, Justice Mimi Chan. Now, next slide, please. So, having spoken about the importance of an arbitration agreement, I'm sure many in this room would be curious to know what is a good example of an arbitration agreement. So I provided a sample SIAC arbitration clause that that you can use and just put in the relevant information. You can tailor it, whether it's one arbitrator or three arbitrator, what the language should be, where the seat is, what the governing law is. So this is a sample SIAC clause. Next slide, please. So I mentioned earlier about arbitral institutions. Now, they form an integral part of the arbitration because they contribute to the civil procedure, as it were, of the arbitration. What's the process for challenging an arbitrator? How many days do I need to submit a certain thing? What are certain steps in it? So different arbitral institutions have different processes on how to challenge an arbitrator, when to file their pleadings, for example, what rights and recourses or special remedies that you might have. So next slide, please. So we've actually produced a very helpful table comparing the different arbitral institutional rules, the different aspects of it. So we have ICC rules, SIAC rules, HKIAC rules, and LCIA rules, which are the four really main, most dominant arbitral institution rules. And we've done a table comparing various aspects of it. How do you appoint an arbitrator? What's the difference in these areas? Next slide, please. Again, you see, this is another slide containing what are the differences. So, for example, in terms of confidentiality, and what's the time limit for issuing the final award? Different arbitral institute have different deadlines for it. Next slide, please. And last but not least, different arbitral institutions also affect the cost of the arbitration itself. They have different ways of calculating the cost. So again, we have put a comparison of the ICC, SIAC, HKIAC, LCIA using a figure of I think about 100,000 or 1 million USD. What is the cost of the arbitration? So we put down in this very helpful table. And I understand that it's very hard to read over here, but if members of the audience are interested, they can reach out to their SIP lawyers to ask for a copy of this, which I think would be quite helpful. Next slide, please. And that concludes the end of my presentation, and I hope that it's been helpful to everyone in this audience to know more about what arbitration is, what are the steps that we can take, how do we draft an arbitration agreement, to try and safeguard the rights of our company and all that, and what can we do, to try and set aside an award or to resist the enforcement of the award. So thank you very much for your kind attention. Thank you.